My lord, under company then my lord, old method 2012, State Bank of India service.
Today is the not the date. Issued show cause notice as to why the grade pay would not be cancelled in terms of the DOPT's Office Memorandum Number 35034/3/2008/ESTT within bracket D, dated 19th May 2009. Paragraph 7, page 5 of the report. Check up the number. Step. Vide Memorandum Number 62/2016, dated 17th April 2016, the board cancelled the earlier Office Memorandum Number 09/2012, dated 9th January 2012, by which the grade pay was upgraded to rupees 4200 instead of grade pay of rupees 2800. Stop. A direction was passed to refix the payment of those employees who were wrongly benefited due to misinterpretation of the extant norms. Challenging the said refixation, the instant writ petition was filed. Though an interim order was passed by the court on an earlier occasion, but thereafter, with the order dated 11th March 2021, the writ petition stood dismissed and the interim order stood vacated. Stop paragraph. It has been submitted by the learned advocate representing T-Board that the employees refunded the excess amount received by them and the matter ended. Stop. It is only the writ petitioner who has tried to revive the proceeding by filing the application seeking restoration. Stop. It has also been brought to the notice of the court that the service of the petitioner was that the petitioner was dismissed from service, which the petitioner challenged by filing a separate writ petition, and the court was pleased to interfere the same and set aside the order of dismissal. Stop. The petitioner has, however, retired from service currently. Stop. Next. Upon hearing the submission made on behalf of both the parties and on perusal of the documents before the court, firstly, the court is not satisfied with the reasons given by the petitioner seeking recall of the order of dismissal.
Here is my opinion opposition.
Stop. The period of delay in filing the application is 1964 days. Stop. By merely putting the blame upon the learned advocate that he intentionally stayed away when the matter was called for hearing, and also alleging sabotage by accepting extraneous consideration, the petitioner cannot satisfy the court that he himself was vigilant with the matter.
This judgment may go on.
There is nothing available from records that the petitioner himself was aware and vigilant with his matter. Stop. Had the petitioner taken care of his matter and regularly kept in touch with the learned advocate, then he ought to have approached the court earlier with the recall application. Stop paragraph. The paragraph. Secondly, on merits also, it appears that that certain benefit, financial benefit, was granted inadvertently in respect of 33 employees, and upon perusal and upon detection of the error, the same has been sought to be rectified. Stop. It is not expected that an error which has come to the notice of the authority has to be perpetuated. Stop. The error is required to be rectified as soon as the same is detected. Stop. Such error has since been detected by cancelling the order of upgradation of pay. Stop. In view of the above, the court is not inclined to interfere in the applications. Stop. Both the applications stands dismissed.
Yes, my lord. Only thing is this, my lord. Kindly record this judgment, my lord. So I am placing before lord. Kindly record. Now, my lord, this will be travesty of justice, my lord. If your lordship, in spite of my difference, my lord, if your lordship does not record it, my lord. And lastly, my lord, your lordship, the recovery has been detected, fault has been detected, but my lord, interim was there. They got the interim was dismissed, and my lord, dismissed for default, interim was vacated, and they took the advantage of that, my lord.
Call the next matter, please.
My lord, this is a gross error of my lord. Well, my lord, this is not the last court, my lord. We will see to it. How the order stands of your lordship.
My lord, I beg to appear for the petitioner, my lord.
Yes,
My
please.
lord, I've been led by Mr. Bilodol Bhattacharya. Unfortunately, is not in court today. But I was praying before your lordship, innocuous prayer. My lord, I need instruction from the petitioner as well. Kindly make the matter go out of the list so that I can mention the matter whenever, my lord, or else at least adjourn the matter for the week, my lord, at least.
That can be done.
Well, kindly
But
do
if the
that.
cause of action no longer survives, then I would like to finish it off.
My lord,
And not give you another handle to re-agitate again.
no,
If
definitely,
there is
my
a
lord,
fresh
my lord,
cause of action, you can
my
always
lord,
come.
I bow down to your lordship, my lord, definitely. But kindly,
After adjournment,
kindly
I'll adjourn.
adjourn it for a week or so, my lord, if convenient to your lordship's.
All right. Accommodation has been sought for on behalf of the learned senior counsel representing the petitioners. Stop. None appears on behalf of the respondents. Stop. Let notice be served upon the respondents. Released for further consideration on 29th of June.
Grateful lordship.
Item number 4, my lord. The amount has been transferred to the account of the petitioner subsequently, my lord. Now I have received.
I am appearing on behalf of the respondent number 9, and we are the payment authority. We have disbursed the payment way back on 30th March 2026. And after compliance, and after due compliance of all the formalities, we have received the money.
21/5/2026, my lord, the money has been transferred to the account of
When?
21/5/2026.
21st of May.
This is the
Yes.
1,69,000.
Learned advocate representing the petitioner submits that a sum of rupees
1,69,000.
1,69,919 has been credited in the bank account of the petitioner on account of provident fund use.
Yes.
Right? So the
Yes.
petition ends.
Yes.
Paragraph, the grievance of the petitioner has been redressed. Stop. The writ petition accordingly stands disposed of.
Grateful to your lordship.
What is 6? What is 5?
5 is the
MMCC.
Your Lordship, last occasion, Your Lordship directed them to release the amount of MMCC.
MMCC.
Yes, my lord. That has not been
Sanction, my
released.
lord. But we were process of sanctioning, my lord. We had process, my lord. During process, my lord, two major discrepancy has come up, my lord. I just need to show to your lordship, my lord. Kindly takes, my lord. This instruction came to me, my lord, just last night, my lord.
Yes, Tegi.
My lord, the petitioner, my lord, has, my lord, deposited before us, my lord, the Aadhaar card, PAN card, and the account number in which, my lord, he wants the MMCC, my lord. Now, my lord, if your lordship sees the Aadhaar card address, my lord, first kindly see, my lord, second page.
No. Why is the court required to see if there is any
But two
discrepancy?
reason, my lord.
Let the
Yes, but
petitioner
two
know.
reason, my lord.
Let him rectify.
But two reasons, my lord. First, my lord, the address which they are saying, my lord, that in that address, the police verification is saying that nobody is staying there. One, my lord,
This
the
is the
relationship
document that is
also, my lord,
already
when, my lord, we are also, my lord, when we are going for relationships, my lord, the police is verifying that there is no document to show the relationships, my lord. Second, my lord, and third, my lord, the major thing is that, my lord,
How
the
was
person-
Provident Fund dues
the
given?
person, my lord, on the
1 minute. How was Provident Fund dues released?
my lord, that's I also don't know, my lord. My lord, this, my lord,
The petitioner is a single individual.
but my lord,
At the time of releasing Provident Fund, which was due to her husband, you accept it.
Yes.
And now when she wants MMCC,
Provident
you
Fund-
say there is no relationship between the husband and the wife.
But Provident Fund, my lord, so every paper was produced, my lord, and the process, my lord, just
If check up, you call for the papers from the
This
petitioner.
document, I have
Let the
already
petitioner
not the
go.
problem, my lord. But I will leave to your lordship. Whatever your lordship will direct, my lord, we will do that, my lord. That's my
Why do
instruction.
you require direction from the court? Can't you all work independently?
But
You
because,
want a litigant all the way from all those coal mines to approach the court only for these reliefs.
no, my lord, because, my lord, according to our procedure, my lord, the two things has not been verified, and thirdly, the
Please
major thing.
verify what is where is
The major
required to
thing,
be
my
done.
lord, is that, my lord, the person who died, my lord, so he has declared, my lord, his wife age to be in 1957. And the document which he is showing, my lord, his age is 67, my lord. But 8 years difference is coming, my lord. My lord, the document which he is producing now, my lord, kindly see, my lord, just the Aadhaar card, my lord, kindly see the
Aadhaar card is not the proof of his
PAN certificate,
the age.
PAN
PAN
card,
is also not the proof of age.
and my lord, kindly see the records, my lord. My PAN card, my lord, page 12, my lord, kindly see that it is, my lord, 1/1/1967. This he has produced now. Now, my lord, now the record, my lord, the service record, which, my lord, first page he has annexed in the read petition, second page he has not annexed. That, my lord, at page 7, page 6, my lord.
Please
Kindly
come.
see-
The matter relates to payment of MMCC to the petitioner number 1. Stop. Learned advocate representing Eastern Coalfields
my lord.
submits upon instruction that there are certain discrepancies in the documents submitted by the petitioner. Stop. Let the discrepancies be made known to the petitioner. Stop. Let necessary correction be made. Correction/rectification be made. Stop. Release the matter for further consideration on 6th of July.
Just put it on.
Status of the claim of releasing MMCC shall be made known on the adjourned date.
My lord.
they may ask her to inform to the petitioner what discrepancy.
Yes, they
I'm
will
just-
immediately. Give a copy so that he also gets to know.
Suddenly they
But I have
came
given
and-
the instruction and copy everything, my lord. It is clearly mentioned, my lord.
My-
Item number 6.
6 for the petitioner, my lord. But I will be tendering unqualified apology, my lord. There was a direction upon me to take an exception to the report filed by the respondent. But I contacted the client. He is bedridden, absolutely ill. I had a conversation with his wife also. But kindly grant me 2 weeks' time as a last chance. If he doesn't turn up, I will be proceeding on the basis of the writ petition.
On the prayer of the learned advocate representing the petitioner seeking extension of time for filing the exception to the report filed by the authority, hearing of the writ petition stands adjourned till 20th July 20. Stop. Exception may be prepared and circulated by 15th of July.
Grateful to you. Much obliged.
Grateful, madam.
Hello, I'm for the petitioner led by Mr. Partha Ghosh. He is appearing online.
I appear for the respondent.
I cannot hear you, Mr. Ghosh. Please unmute yourself.
My lord, am I audible, my lord?
Yes.
Here, my lord, the mother of the petitioner was an employee of the Eastern Coalfield. Now, mother has died, my lord, in 1995. Now, my lord, during that period, my lord, I was minor. My father, he was also an employee of ECL. He made an application on my behalf for keeping my name in the panel of life roster so that I can be given employment as and when I will attain the age of majority. And during this period, my father also prayed that monetary compensation is to be paid to my client. Now, thing is this, my lord. Subsequently, my lord, a series of application was made. I have also made application, and they have rejected my application on the ground that page 37 that I am not entitled because I was minor at the relevant point of time. Now, the NCW says, my lord, that the male dependent is entitled for monetary compensation for keeping his name in the life roster, and female dependent will be, my lord, given the monetary compensation till he attain the age of 18 years, and, my lord, and provided with employment. Now, if you lord should kindly come page 37.
Has affidavits been exchanged?
My lord, report,
Yes,
I think,
yes,
my
my
lord,
lord.
report and exception, not the full-fledged affidavit, only to the short point, my lord. It's-
My lord, all
So,
point
on
has
the
been
basis of the report, it can be disposed of?
My lord,
all point have
my
already
lord,
been dealt with.
because
Now,
the
my
point
learned friend
legal
first time
points.
appearing.
It's all legal point. There
the
is
Yes.
legal
nothing.
points, my lord, I don't think so. Just going for this full-fledged
Affidavit
affidavit,
is
my lord.
required. All right. Yes, please.
My lord,
But
my
let
lord, may
Mr.
I,
Ghosh come submits today. I will come back, my lord.
my lord, may I read page 37, my lord?
Yes,
Despite,
37.
my lord, despite clarifying the relevant clauses under NCWA in connection with the employment to the dependent, payment of monetary compensation to female dependent by letter number such and such, as subsequently again letter dated such and such, same grievance has been given raised by you through your application dated such and such, received on Ato, ACL Saktoria on Ato, and subsequently received on this Ato after Ato. It is, however, once again clarified that the monetary compensation is given to the female spouse of the deceased employee in lieu of her employment on request of female spouse concerned. Accordingly, you are not eligible for any maintenance cost oblique allowances. Now, my lord, if your lordships kindly see the NCWA, that dependent, who are the dependent first, my lord, because they have only said that I am the child.
Give the NCWA. Give.
My lord, it is already
My lord,
quoted.
I think, my lord, you don't
lord,
have. I have a copy, my lord. May I?
My lord, let my understand, my lord.
My lord, I have a copy, my lord. May I?
1 minute. 1 minute. Let me see. Is this the
Compilation. I think this
My
is the
lord,
compilation of the, or maybe, my lord.
my lord,
NCWA.
my lord, it's not required. My lord, kindly come, my lord, payment of my rate application. I have reproduced the provision, my lord. Page 11 of my rate
My lord,
application.
it's better, my lord, if your lordship takes it, my
1
lord.
minute?
Only
Page
the
11. He says it
Mr.
is there.
Das,
Page 11.
Mr. Das, please allow me because I am.
No, I am not disturbing
Yes,
you.
yes.
So
I'm
please
just
don't.
He is
Please.
allowing
the
you.
NCW.
Page 11 of what?
Of rate application, my lord. Paragraph 21.
Oh, you've set it out.
Yes, yes.
All right. Yes, page 11.
Yes, the dependent for the purpose means the wife, oblique husband, as the case may be, unmarried daughter, son, and legally adopted son. If no direct dependent is available for employment, brother, widow daughter-in-law, or son-in-law residing with the employee, and almost wholly dependent on the earnings of the employee may be considered. So, my lord, daughter is there, and daughter is entitled for employment. Now, my lord, 9.5.0, if your lordships kindly come. NCWA provides for employment oblique monetary compensation with female dependent. The delivery extends. Again, I have extracted the employment and, my lord, the monetary provision. 9.5.0. Kindly see, my lord, the provision of employment oblique monetary compensation to the female dependents. So, unmarried daughter is covered under female dependent of workman who is die while on service and who are declared medically unfit as per clause number such and such. Now, the other provisions I have also quoted that if the female dependent is above 45 years of age, she is only entitled for monetary compensation. If she is below the 45 years of age, she have the option either to accept the monetary compensation or my lord employment. My learned friend Mr. Das is also knows this provision. Now, straight away, my lord, I am coming to the my lord judgment because this is the only fact they have cited and they have my lord rejected. My junior will my lord hand over to your lordship the judgment. As my lord Putul Ravidas, your lordship knows. Sukumani's judgment, my junior will provide, my lord. That has been affirmed by the Honorable Supreme Court. I don't have one extra copy with me, my lord. So, your lordship will find that the division bench judgment of this Honorable Court has, my lord, allowed the monetary compensation and the employment, either one.
See, if it is below 45, then either monetary compensation or employment.
Yes.
You
Now I'm
were
asking.
a minor at that point of time. So
Yes.
question of employment does not arise at all.
Very well, kindly allow me monetary
And
compensation from the date of death.
monetary compensation is payable to the spouse.
No, my lord. Here, my lord, monetary compensation is to be payable spouse as well as the daughter. I have shown to your lordship the provision, and your lordship will find, my lord, the judgment of
The
Sukumani
spouse
Hemno.
of the deceased was already serving ECL.
Yes, that is male. Male spouse is not entitled. Only female spouse they have said. So male is not entitled.
No,
My
no,
father.
the dependent for the purpose means the wife or the husband, as the case may be.
My lord.
Now the husband is already employed with ECL.
Yes. Thereafter, kindly come, my lord.
Where is the question of giving the monetary compensation?
Well, I have shown to your lordship, my lord, the 9.5.0, page 11, page 12, my lord, of my writ application.
9.5.0.
The provision for of employment oblique monetary compensation to female dependents of workmen. So, my lord, female dependent is, my lord, the daughter. At the top, my lord, you will find the clauses of, my lord, the dependent. That is, my lord, in the same, my lord, the standard of the NCWA, you will find that two categories of dependents are there. One is direct dependent, one is indirect dependent. Direct dependent means, my lord, the wife, oblique husband, as the case may be, unmarried daughter, son, and legally adopted son. This is the direct dependent. Same pedestal. Now the second category.
Show me the report once.
Report they have supplemented many things, which is not permissible under the law.
Not submitted many things.
My lord, here they have rejected on the ground that the female dependent, that the daughter, unmarried daughter, is not entitled. That was their ground for rejection. Now they have developed their case through their report. The Mahendra Singh Gill's case, your lordship knows, and many judgments are there, my lord, that they cannot supplement their decision through their report or affidavit in a writ proceedings.
What is the decision that you are relying upon?
My lord, the Sukumani Hemrom.
Yes, sure. Give me, please.
Same argument they have advanced. My learned friend possibly
Where?
appeared.
Which paragraph, please say?
Well, kindly see the, actually I don't have the copy. Your lordship will find the last, entire judgment is relevant, but your lordship may, my lord, see the last page of this judgment, my lord.
It is on behalf of the response since the appellant was a minor at the time and she is not able to participate in the bond compensation. In terms of the compensation.
44, 43 and 44. Test. Not going to correct 9.1. Yes, yes. We find we have stated 9.4.3. Not correct. Dependent. Negative substitute for the we have to correlate with that input for the consequences. If we correlate it to the mean figure,
In the matter of Shukhamani Hemram,
My lord.
what was the prayer for grant of compensation or the
My lord,
employment?
my lord, both prayer was there, and the
The
last
prayer was
paragraph.
there.
And last paragraph, if you will kindly see, last page of this
Yes, last
judgment.
paragraph.
Your lords will
Granted
find.
to grant compassionate appointment to the appellant as expeditiously as possible.
Yes. No, I am not, my lord.
What is your prayer for grant of compensation or for
both.
employment?
Both.
My lord, I have
Have
prayed, my lord.
both.
My lord,
Yes,
I have
please.
prayed.
Either of the two.
But yes, that was
No,
my.
So whatever is given to you, you are okay with it.
No, actually, my lord, if your lords will kindly see the provision, my lord.
Election will come into play.
What
Your
is
lords
your
will
age
find.
now?
My age is now
5, my lord.
Below 45 or above?
31 years.
Below
So you are entitled to compensation also.
Very well, my
No
lord.
question of
Okay, very well. As your lordship deem fit, my lord, I will not, my lord, press. Your lordship may allow compensation from the date of death.
no, wait, you are entitled to appointment. Why will you not
Yes.
work and only get compensation? You work and
Very
then get
very
paid.
well, my lord. Very well, my lord. I am also agreed, my lord, if your lordship allow my lord appointment.
So you are all right with either of the two, either work
Yes.
or
Yeah, very well, my lord.
compensation. Very
Very
well, I
well,
got it.
my lord.
I got your point.
My
Yes,
lord.
please.
No, my lord.
Will you
My
make
lord, it will
submission
take
on
some-
the
no,
next day?
Yes, yes, my lord. Kindly keep it on Thursday, my lord.
Thursday?
Thursday, my lord.
All right.
Thursday, my lord.
Please.
Because I will, my lord, I tell it when Mr. Ghosh is there, my lord, that I will take the maintainability point of the writ petition first.
All right.
I have 5 points. I will
Did you take the maintainability point in your report?
Yes.
What is the maintainability
That
point?
it's not maintainable here. So it's an industrial dispute. Should go before the CGIT Asansol. I will elaborate.
And was this issue taken up in Shukhamani Hemram also?
No.
This
And
point
I will
was
distinguish Shukmani Hemram with the Supreme Court judgments also. I will
all right.
distinguish.
Please
And
my lord,
one thing, my lord, Mr. Ghosh has cited, my lord, that he has stated that clause 9.11, my lord, 9.4.03 of the NCWA 5. That's why, my lord, I wanted to give a copy of this
next day
NCWA
you
5.
give?
No, my lord, I will give, but it should not be 9.4.03. Mr. Ghosh is mistaken, my lord. It
All
should
right,
be
whatever.
9.3.3.
my lord, may I pray, my lord, because 18, my lord, from 18, my lord, our sessions will start. So if your lordship kindly fix before that on 17, my lord.
No, 17th, my lord. I have a matter fixed in the morning, my lord. Court number.
Fast sessions, my lord. So
13.
I don't want
Maybe,
to
my lord,
miss.
but I have court number 13 matters fixed. In appeal, my lord.
Last
and
day,
your lordship knows,
my
my lord,
learned
it will run.
friend taken time.
No,
Today
I have
also
not
he is
taken.
not adjusting.
But
Last
why
day
I
here,
taken
my
time?
learned
Because
friend
that
has
was the
taken
first
time.
day. I
Because
said that
my
I will
learned
take
friend
the
knows
First
very
time
well.
MLA fast session. You cannot
Fast
expect
session.
him to miss.
But 17th, my lord, I cannot do it, my lord. I am expressing my mind.
And how long will the session continue?
My lord, possibly, my lord, till my lord last of this month. I don't know exact date, my lord. Not yet, my lord. The notified dates. So this is the difficulty, my lord.
Then I'll keep it after that, because if
Very well,
your
my lord.
learned
Kindly.
friend has a problem on the
Very well,
18th,
very well, my lord. Then after that, kindly, my lord.
I'll keep it
Kindly,
in
my lord.
July.
Very well, my lord. Very well.
But only record, my lord, Mr. Ghosh has concluded his submission today.
No, I will reply.
No, reply is separate. But then
Yes.
otherwise you have concluded.
Yes. Main point I have concluded. If my learned
Very
friend
well.
Whether
supplements,
there are
then
ancillary points, let him say, my lord. Otherwise, next day again he will start.
My learned friend, if
The
my lord
court accommodates.
supplements,
It's not
No, no,
that the
no,
court is
let
so
it-
rigid.
No, court is not at all rigid,
Then
this court.
the impugned order dated 19th of January 2021, rejecting the prayer of the petitioner for grant of MMCC is impugned in the instant writ petition. Stop paragraph. Learned advocate for the petitioner submits that the petitioner will be eligible to receive eligible for compassionate appointment. She will also be eligible to receive MMCC. Stop. Reliance has been placed on the judgment delivered by the Honorable Division Bench of this court in the matter of Shukomani Hembrom, please check the spelling, versus Union of India and others, reported in 2024 SCC Online Cal 7361. Check up the spelling. Stop. It has been submitted that the order passed by the Honorable Division Bench has been affirmed, has not been interfered with by the Honorable Supreme Court in the special leave petition filed by the respondent authority. Stop. To allow the learned advocate representing the respondents
Yes,
to
you're right.
commence argument. Release the matter for further consideration on 8th July 2026.
On 8th July.
No further
8th July, my lord. 8th July. All right.
get full dealers.
Get, my lord.
My lord, item number 8, 9, my lord, I supposed to file the supplementary affidavits. But the
Lordship, in
petitioner,
8 and 9, Lordship, I am for the respondents. I mean, led by Mr. Bihani, this matter.
the petitioners did not get.
The matter is not being taken up today.
My lord, then kindly, my lord, after 26, my lord, they will get leave and they will come to the, they can come to the High Court to affirm these affidavits, my lord. They are in North Bengal.
All right.
And they will take it only after 26, my lord. Any day, as per my lord's convenience, after 26. And my lord, another matter, analogous matter I have filed, but that is not been listed, my lord. 196, WPO 196.
WPA.
WPO. Analogous matter, my lord.
All right. It will appear.
Lordship,
order, please take down an order.
Lordship, I am appearing on behalf of the state respondent led by Ms. Shushmita Shahadato, learned AGP. Lordship, on the last Friday, I received the notice from the AOR, but I have not received any copy of the petition. Lordship, kindly
Which
direct
petition?
this WPO.
Isn't it there in the Sharthok?
No, not available in Sharthok.
The original side, ye Sharthok e thake na?
Thake na.
It will please tell your government to upload all the writ petitions as done in the appellate side, in the original side also to be uploaded in the Sharthok and take copy from there. And in case you want copy, you can collect copy by paying your own charges. And then because the petitioner has already submitted 2 copies and you cannot expect copy after copies to be submitted to the state. On the prayer of the learned advocate representing the petitioner.
Informed your clerk also.
Lordship,
Release the matter for further consideration on 7th of July.
7th of July. 7th
Lordship, can I see?
6th July. All right, 6th.
And my lord, this matter will be appeared, my lord, analogous. Should be appeared.
All right. 8 and 9.
8 and
And the counsels who are present here, it is only those appearances that will go down in the order sheet.
2 to 7, Lordship.
হ্যাঁ ওর সাথেই আসবে একসাথেই ফাইল হয়েছিল কিন্তু আসছে না হ্যাঁ হ্যাঁ অদ্ভুত ব্যাপার কোথায় ফেলে রেখে দিয়েছে কি জানি
Grateful.
Cabinet side, item number 1.
হ্যাঁ আচ্ছা ঠিক আছে বুঝে গেছি
Lordship, I beg to appear on behalf of the respondent bank. Your Lordship, because of fever, I am unable to attend physically, Your Lordship. So seeking leave, Your Lordship, to kindly allow me to make submission virtually.
where
Lordship.
is your report?
Your Lordship, my report is ready, but I have been informed by the bank that the document which the bank intends to incorporate, because the petitioner is guilty of suppression of facts. Earlier, the son of the petitioner has filed a writ petition before the honorable courts. The writ petition was taken up
I
for
want
hearing.
to see the report. There
Yes,
was
yes.
a direction and a time
Yes.
limit fixed. Where is the report?
Lordship, that is not yet ready. Bank is tracing the documents. Lordship, subject to Lordship kind consideration and accommodation may be given to me so that I can file the same.
How long?
Lordship, 2 weeks time may be given. If nothing is, what will be there, I will file. Report is ready.
On the prayer of the learned advocate representing the bank, seeking extension of time for preparing the report in terms of the order dated 19th March 2026, comma, time to file the report, time to prepare and circulate the report stands extended till 6th July. Release the matter on 20th July. Exception to the report may be filed prior to the adjourned date. Affidavit service filed in court today be written with the records.
Lordship, oblige you.
Two, I am for the petitioner. My lord, I have served upon twice, my lord. Again, I have served 2 copies of the petitions, 2 affidavit of service. This is the, my lord, the CPF to GPA, only area pensions petitioner's claim. The petitioner
Similar order?
Similar order. And what happened, my lord, the petitioner is 92 years old. The writ petition was dismissed for default. And I have filed an
Petition was dismissed, so it has to be recalled.
I have, yes, my lords, the dismissal, my lord, the order was passed by my lord. I have filed an application for restoration as well as the, my lord, the condonation of delay. Two can is there. Kindly, my lord, considering the age. This is the order I have, similar order I have corrected copy.
July 2024.
Yes.
And it is filed in March 2026.
And there is also application for condonation of delay. My lord,
now the application is not being filed by the petitioner. Application is filed by the son. Why the delay? Why the delay?
That I have stated, my lord, the son by the petitioner, because, my lord, the 92 years old, he cannot
It
come.
is all right. So if the son could come, why such delay?
Yes, I have stated, my lord, the paragraph 5 and 6.
No objection given.
Yes, yes. That I have annexed, my lord, the vocal now.
Aja, please come.
My lord, I have been instructed to appear in this matter. I will take the copy from the Sharto.
Please. একটা restoration আছে ওটাকে allow করবেন considering the age of the petitioner. Petitioner is aged about 90 years. ঠিক আছে দুটো ক্যান ডিসপোজ হলো একটা হচ্ছে সেকশন 5 আর একটা হচ্ছে রেস্টোরেশন। হ্যাঁ, but the cans are not there in the list. What is 3? Can 3?
Can 3, so my condonation of delay.
There are three.
Then can 1?
Can 1, my lord, I don't know, I have not been supplied, my lord, the can 1.
Can 1 নেই?
It is a days list can be disposed
আচ্ছা,
of.
can 2 আর can 3 আছে। ডিলে কন্ডোনেশন আর কি বলে রেস্টোরেশন। ঠিক আছে, এই দুটো হলো can 1 is not readily available as the writ petition is disposed of, connecting application be treated as on days list and be disposed of. Can 1 টা treated as on days list and disposed, ওপরে কিন্তু লিখে দেবেন not in the list। যদি না ডিসপোজ হয়ে থাকে, শৈলেশ প্লিজ চেক ইফ can 1 has been disposed or not. আচ্ছা, আর এটা রিটায়ার ফ্রম সার্ভিস এর এত তারিখে। The dates are all right over here.
Yes, yes. Only paragraph 9.
Paragraph 9.
Director of Pension and Treasury Officers, you will also kindly add, my lord, the district inspectors. My lord, for revision of pension, there is some process by the DI also.
Which DI will be?
DI will be PE Howrah, Primary Education Howrah.
All right, disposed. This is the order. Can 1? Huh? বলছে পেন্ডিং, অল পেন্ডিং। আমি বললাম তো ট্রিটেড অ্যাজ অন ডেজ লিস্ট করে ডিসপোজ করবেন। Yes, next. 3.
Kindly take up tomorrow, my lord. I have given notice to move tomorrow.
All right, tomorrow. Not today.
Not today. 4 I am for the petitioner. আবার সার্ভ করলাম, ডবল করে সার্ভ করছি প্রত্যেকটা, মানে two episode of service previously served again after upon mentioning. This is, my lord, your lordship, kindly turn to page 23. 23, my lord, petitioners, my lord, participated at the selection process for primary teacher, and she appeared on 20th December 2009. You also got it, my lord?
Yes.
After the written test examination, panel was prepared, my lord, panel was prepared, but the petitioner was not included in the panel, my lord, because of she obtained PTTI from the institution not recognized by the NCT. My lord, the Tulsi Boxi's case, my lord, these petitioners, number of others matters, moved the writ petition that have annexed page 24. My lord, the petitioner is also one of the petitioners.
What is the immediate release that you got?
That writ petition was dismissed. Again, all of them preferred an appeal and up to the Honorable Supreme Court. After the Supreme Court order, my lord, the dismissal of the SLPP filed by the estate, my lord, the ultimately petitioner got appointment paid 109.
Yes.
My lord, he got appointment 109 on 1st August 2025, and she joined on 13th August 2025. And my lord, she retired from service on 20th February 2026. Only she worked, my lord, the 4 months.
And she wants pension?
A notional benefit, my lord, should be given, my lord. There is a judgment of your lordships, my lord.
Yes, but only with 4 months, I think I will not allow.
No, my lord, this is a selection made, my lord, the 20th August 2009. Written test. Panel was prepared, my lord, the 2010. I want national benefit, my lord, the monetary benefits I am not asking. Only, my lord, there is a judgment of your lordship.
It is better you get it done from the other bench. No, right
Your
now.
lordship's judgment, my lord, there is, my lord,
No, nothing.
She is
Even though the petitioner seeks notional benefit. Let the matter appear before the regular bench. Staff learned advocate representing the respondent shall come ready with necessary instruction on the urgent date. Affidavits of service filed in court is taken on record.
Yes. 5, I am the petitioner. I am praying for similar order. এই অর্ডারটা দিয়ে দিন তো যশোরকে। My lord, petitioners, my lord, the widow of the petition, my lord, the upon refund of the government share, my lord, the
Which DI?
DI Uttar Dinajpur. Same DI.
All right, same order. Service taken on record.
2, 3, 4, 2, 3, 4, 5.
Item number 6, Mr. Ikramul Bari is appearing in this matter. A short passover.
Passover?
Short
All right, call him. Passover.
Yes, my lord.
Passover, item 6.
Yes, I am for the response.
7.
I appear for the petition, mate.
I am for the
Page 26 is an impugned order.
এটা ব্রিফটা দে
Now I have
Page
challenged this.
26.
The order issued by the Director of Mother Education,
Yes.
by which singing of Bande Mataram has been made mandatory to all madrasas. Now, this I have challenged.
It has been made mandatory in respect of all schools.
All schools and madrasas.
Where is the problem?
Now, the problem is that, first of all, I have challenged this basically on 3 grounds. First, recitation or singing of Bande Mataram. There are few lines which contravenes of right to religion of some Muslim communities who doesn't believe in more than one goddess. This is first. Second, your lordship knows that constitution statutes, executive order can be issued in respect of the field which is not occupied by the other legislation. Even if the executive order is issued, that has to be issued in the name of the governor. Now, this order has not been issued in the name of governor. That apart, this is first part. Even if I assume this is an executive order, this is not an executive order in terms of constitution. Second, the management of madrasa and the madrasa education is already occupied by an appropriate legislation and the rules and regulations framed thereunder. Therefore, there is no scope for issuance of any executive order, even in the executive order, in that field. I'll be citing judgments on that. And the third is that it contravenes Article 25. There is a judgment of the Honorable Supreme Court which is relating to a national anthem. The students of a particular school were suspended suspended on the ground that they refuse to sing that anthem on same ground of religion. Supreme Court has held in our favor in that judgment. I'll be therefore
Supreme Court held that the national anthem is not required to be sung?
No, not required. If somebody chooses not to, then he may. But these are ultimately fundamental duties. They can only enforce fundamental duties. But Supreme Court says if somebody chooses not to, that will not hit that provision. But so far the first part is concerned, this is all my submission is there is I must tell you, there is
You must be aware that Vande Mataram has been declared as the national song of the country by the Union of India.
Prior to that, even prior to that,
in February, in this year, January or February sometime.
There, I have annexed that.
Yes.
There, specific, if you kindly takes up.
Where is that order?
That page starts at page 29. Now, kindly take the page 31, last paragraph.
No, but where is that order?
Page 30, starts with page 20.
No, there is a specific order that it has been made.
No, it starts with page 29, yes.
29 is the national song. You've taken down the whole thing. And what is to be done? But then there is a notification also.
No,
there is a particular notification.
This is a national song that has been decided in the Constituent Assembly in 1950.
Yes. Now it has been made mandatory for
mandatory, that's my point.
In all official occasions.
Kindly take up page 31. It is not made mandatory. That's the Supreme Court that is challenged.
This is not so much of importance that the court has to interfere.
It is important. To the extent it is important. 31, can you take some blood?
31?
Yes. Last paragraph.
Yes.
In all schools, the day's world may begin with community singing. This central government notification says may, not made mandatory. That's why when it was challenge was made to the Supreme Court says that it is not mandatory. If anyone takes punitive action, you come. Here, in our state, it has been made mandatory. The language is different.
All right. You give the judgment, I'll record it in the order and he'll go through it and come back. Please give. There is no so much of urgency.
Urgency to the extent is school cannot compel me to sing it.
All right. No punitive action has been taken as yet.
Can you record that?
No, yeah, exactly. You give the judgment so that it can be referred. He'll look into it and come back.
The judgments of national anthem or for this one?
What's the judgment?
For the national song.
National song, it was dismissed in one line. There is most of the things has been reported in the live law where my court has observation of the court.
The citation must be there.
No. So one line order. Court has observed orally and that has been recorded in live law.
It is sure.
That it is not mandatory.
All right, please come.
But it is not precedent to all. It is possible on the judgment, the copy of the judgment.
Wait. Now you have to find out copies. You cannot seek copies from the petitioner. Achha. Who is the petitioner?
That is the student of a madrasa. The father of a student.
Father of a student. The petitioner claims to be the father of a student of a madrasa. Stop. He is aggrieved by the order dated 19th May 2026. Passed by the Director of Madrasa Education, West Bengal. Whereby singing of Vande Mataram during assembly prayers prior to commencement of classes has been made mandatory in all madrasas under the Minority Affairs and Madrasa Education Department across the state. Stop. Where is it mentioned that if no punitive action is taken, nothing of this sort?
No, that is an observed in the that I have handed over the live law part.
No, that will not do. Observations doesn't make part of the order. You know it. Then what is the use? A court can make so many submissions, observations, conversations.
Supreme Court usually, when dismisses the petition, doesn't record all this. But it was the observation of the court. Was the reason for dismissal is that this, since it was not made mandatory. Can I make a distinction between the central and state that it was may and.
ঠিক আছে
I must tell you, Lordship, one thing. There is a letter of Jawaharlal Nehru to Subhash Chandra Bose in the year 1937. There also he has requested that first two lines should be there, not the rest one. The first stanza should be there and not the rest, and that's for the same reason.
Answer next. It has been brought to the notice of the court that as of now, no punitive action has been taken for not singing the Vande Mataram during assembly prayers in the madrasa. Stop paragraph. According to the petitioner, the petitioner, singing of the national song will infringe the religious right of the petitioner. Stop. Apart from the above, other issues have been raised.
This is not an order in terms of law.
Oh, other issues. What is stop?
Not an executive
order. It has also been submitted that the impugned order is not an executive order and made under the name and style of the governor. Stop. There are legislatures in the field of madrasa education, and there is no requirement of any executive order. Paragraph. The respondents are directed to revert with necessary instruction. Stop. Paragraph. Release the matter for further consideration before the regular bench on 6th July. Enough time.
Madrasa will not take any punitive action. Kindly record.
It has been recorded that as on date, no punitive action has been taken. That I have recorded. And I do not think they are going to take a punitive action so soon. ওটা ফেরত চলে যাবে
এই time for the petition.
Yes.
The matter, the petitioner participated in the recruitment process of 2022 for appointment in the post of assistant teacher. In the recruitment,
just preliminary point.
You are appearing for primary education. What is the preliminary point?
I don't find, my lord. Normally I do not take this.
Do not find any urgency.
Whatever, my lord.
All right.
Now, your lordship, the relief he is asking for is an interim order. At best, my learned friend can get an interim order from your lordships. That's the main prayer.
May I submit my case first, my lord?
No, preliminary objection.
Kindly look at this, my lord, prayer interim order at page 24 and the nature of the interim order. Page 4. Page 24. An interim
directing the board to modify and rectify the merit list
in terms of the marks of the petitioner as mentioned here in above by placing the petitioner. And now kindly see your lordship the prayer D at page 22. That's the main reason.
All right, I have followed it. Yes, what is your
The
case?
recruitment process, petitioner participated, interview was conducted, he participated in the interview test. In the recruitment process, by the dint of the order of the Honorable Supreme Court, 3 merit lists was published. One published in the year 2024, another on 7 January 2026, and subsequently it was lastly published on 23rd May 2026. What has happened, when the list of last merit list was published, the name of the petitioners is featured. Kindly come to page 177 of the writ petition. (177) of the writ petition, and kindly come to serial number 504.
504,
Mustaq Alam, he is the petitioner before your lordships. And kindly see his obtained number to in the category in the total number 28.306. According to the petitioner, his training marks will be reduced by 4 marks. His marks, total marks will be 32.193. Kindly come to paragraph number 18 once of the writ petition. I have stated, I have given the calculation also. Paragraph 18 and 19 of the writ petition, which is at
He has been given less marks.
Less marks. And the marks, if the 4 marks is
on
given,
account of
training qualification.
Training. All right.
Which?
What training?
Training for DLED.
DLED training.
DLED training.
He doesn't have it? He doesn't have it?
Yes.
Then why has
But
marks not been given?
That is the malafide action on the part of the board. Kindly page 13 once. Page 13 of the writ petition. Page 13 of the writ petition, I have given the marks, appropriate marks, which the petitioner is entitled to get. Paragraph 13, page 13.
Oh, page 13.
Paragraph 18 and 19. And kindly see the calculation DL8. He obtained.
So this is your grievance that you have been given 4 marks less.
Less.
And because of this 4 marks less, what has happened?
What has happened? I must be placed in the second panel, which is published on 7 January 2026. And my rank will be 606.
You'll get a better offer at the time of counseling. This is his only case.
I may be given appointment in the month of January when the second panel was published.
Oh, January.
And under the OBC A category, my placement should be 606. That's why in the interim order, I am praying for rectification, modification of the panel.
And what will be the final order?
Final order for appointment.
Appointment?
Yes, there is a vacancy in the recruitment process. If the marks is given, 4 marks is given, then I am entitled to get appointment in the month of January 2026. And the board, my lord, filed an affidavit by saying, registering my name in the 3rd panel, giving my lord, reducing my 4 marks.
All right, just tell me on merits. Are you aware as to whether 4 marks have not been allotted to him, less marks allotted?
I have given the calculation also.
Take instruction.
And representation was given.
You want consideration of representation?
But that's the payer. Payer A is there.
No. This is the absolute case on the behalf of the petitioner.
I do not know. You say you have given representation that is pending. So I'll dispose it off.
No, my lord.
No? Acha, ashun dekhi.
Consider the case. There B.
The petitioner's name has been enlisted in the 3rd list published by the
board,
West Bengal Board of Primary Education
on 23rd May 2026.
On 23rd May 2026 at serial number 504, showing marks as 28.306. Paragraph grievance of the petitioner is that he has been given 4 marks less and his DLED training qualification has not been considered by the authority. Had 4 marks been properly awarded to the petitioner, then he would have been placed in the 2nd list published by the board in the month of January 2026.
Yes, ma'am.
And he ought to have been appointed by now. prayer has been made to direct the board to rectify the marks and to issue appointment letter in his favor. Stop. Paragraph. Learned Senior Counsel representing the board raises a preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that the interim relief and the final relief prayed for by the petitioner is the same. Stop. There is hardly any urgency in the matter to be taken up for consideration by this bench. Paragraph. Upon hearing the submission made on behalf of the parties, it appears that the petitioner has sought for several prayers. As of now, the court directs the board to file a report. Would a report be required, or you'll come with the instruction?
Only instruction.
To come up with instruction. To revert with written instruction as to whether the petitioner would be entitled to 4 extra mark on account of his DLED training as claimed. Released 29th, fortnight's time is granted.
Get from my left. Until 9 for the petitioner.
Yes.
Item number 9, my board has received, but I have not received the bill.
Let us see what he prays, and then if required, I'll call for. Or is it to be taken up today? When will you get the copy? By today?
I shall give the copy by today.
He can get the copy by today also. I'll take it up tomorrow. Day after. When?
Tomorrow, because I am the petitioner. I have the urgency. They 2016 recruitment, they have not published the panel. But what has happened?
Lordship, my Lordship, DPSC Purlia is the wrong information to the petitioner. 404.
After filing the writ petition, they have come with the instruction.
They have DPSC. Total panel has been sent.
May I place the case?
Set aside.
Yes.
No.
Kindly see the.
Give them one more day. Day after tomorrow, your learned friend wants. Come back in the meantime. List নিচে পরশু দিনের ডেট দিয়ে দেবেন।
না এটা রাখো এরকম করবেন। Day after tomorrow. Written is same position, so.
This petition, my board has also not received.
10. Board not received. Check up whether the postal receipt shows.
Let's say I am also not received anything.
Nobody has received. Ensure service. Day after tomorrow, I'll take it up.
In the meanwhile, may I create one thing, because of that, because you two printing out interim order and add interim order is not somehow it means my junior is there, it will be kind enough give a deep to rectify it, and I'll supply the copy of that.
All right.
Kept it day after tomorrow.
Let it be,
1 minute.
No urgency.
Yes. If my lords wants, I can place the urgency.
Wait 1 minute. What is the prayer you want to change?
Because of that is not, I rectified it, but somehow.
Oh, you have not given the prayer?
Yes, but it was given, but somehow misprint.
A, B, C, D, E, F, G.
Yes. Somehow, the earlier copy is printed, so it will be kind enough give a leave, to implement.
Learned advocate for the petitioners to amend the prayer in the writ petition. Stop. Leave sought for is allowed. Let copy of the amended writ petition be served upon the respondents.
Yes, madam.
Day after tomorrow?
Yeah. Day after tomorrow, madam. So,
day after tomorrow.
What Mr. Vishwas and এই নিলয়কে করে দেবে এবং স্টেটের হয়ে নিকুঞ্জ তিনজনকে, হ্যাঁ, নিকুঞ্জকে একে, ঠিক আছে, এখনই করে দাও। গ্রেটফুল, গ্রেটফুল
11.
Well, just one retain its position.
Yes.
Yes.
That matter, my lord, contempt application.
I am here for some of the contemners, alleged contemners number 10 to 14. My lord, I'm trying to establish contact with my clients. They're not answering my call. I have no instruction.
Are they outside or are they inside the jail?
First respondent, first contemner is in the custody.
In custody.
First contemner.
Who's for the state in this matter? Is the state a party over here? In the contempt, principal secretary.
Lordship, we have state was a party.
In the writ petition, the state was a party.
State was a party.
This matter relates to the television industry that is running in the state, film and television industry. Very serious matter. The court took note of it and necessary direction was passed to ensure that the petitioners and anybody who are connected with the film and technical this industry, their right to life and livelihood is not infringed, so that the people can work, because such was the position that they were not in a position to work. Now things are coming out that what they alleged was absolutely true. In fact, the court got an impression when hearing was directed to be conducted by the principal secretary, and it got somehow it fizzled out. I kept the content pending only to see that at least these people can start working. Right? Please ensure that copy will be there in the server. Please check up. Huge volumes and not one writ petition. There were several writ petitions. How many were there? 14 writ petitions were there. Only 2 contempts, but then all writ petitions were dismissed because of various issues. You can check up the order. You can check up the reasons and everything. Come back. I will adjourn it for 4 weeks.
4 weeks, my lord. Next month.
Next month, 4 weeks. Let us see if things
Lordship,
are better in the meantime.
my lord, and a new body is being set up.
Yes.
But instead of the federation, I believe it's no longer in existence because the first contemner is already in custody. So, Lordship will kindly keep it next month, my lord. Because I need to take instructions. They are also
not only you, the department is required to please back up and see if these people can at least earn their livelihood. Very important for them to survive and very important for the state also. Right? To allow the learned advocate representing the principal secretary. Which department will it be?
Ministry of Culture, my lord.
Achha, Ministry of Culture.
Because at that point of time, your lordship had directed for a hearing.
Secretary.
And the report was also submitted.
Principal Secretary কোথাকার একটু দেখে নেবেন তো?
Department of
Information and Cultural
Affairs.
Department of Information and Cultural Affairs. To inform the court the steps taken by the department to make sure that the film and television industry in this state to inform the court whether the film and television industry in the state is properly functioning or not. Release the matter for further consideration on 20th of July. You get enough time. 11 and 12, same order will go down.
My lord, in item number 11, for respondents number 2 to 9, my lord, and my learned friend for 10 to 14, she's appearing, my lord, in person. I mean, my lord, physically. My lord, we had filed wakalatnama, but my lord, we are not being able to contact the persons. My lord, the respondents number 2 to 9 and 10 to 14. My lord would grant us liberty to send, my lord, representations.
Send representation. You want to send representation to your client, and that for that you want leave from the court.
No, not
What
that
type
is
of
not.
submission is this?
Not,
First,
that is,
find out whether they are outside, they are underground, they are absconding, and then make submission.
my lord.
All right.
My lord.
Yes, call the Passover matter, please. My lord.
I don't know.
12 is same order.
I don't know. 6, I appear on the petitioner. Even without looking into the brief, the junior most teacher can be appointed as a teacher in charge. There is no specific rule, but the precedent is there that this all time the senior most teacher is required to be appointed as a teacher in charge. It is a stopgap arrangement. I made an application.
You are the senior most or junior most?
I am the senior most. The person who has been appointed is a junior most.
Private respondent, did you serve?
Yes, it has been served. Now, my lord, I made an application before the school authority. The school authority, page 23, if your lordship kindly.
Yes.
Every service name. Page 23, your lordship kindly have a look.
Request for fair consideration, the post of teacher in charge.
Yes, I'm the senior most approved assistant teacher of the primary department school. I'm writing to bring your attention in matter concern. I have recently been hearing numerous regarding the appointment of the teacher in charge, where it is being suggested some of my junior colleagues.
Has appointment already been given?
But approval has not been given. Appointment was given, but the approval has not.
All right, please come.
Now, your lordship kindly see the.
You are the private respondent?
I'm for the school authority.
Oh, so yes, what is your submission?
Petitioner was appointed for approval under the as per order of this honorable.
Huh.
Petitioner has no training qualification. She passed, my lord, the higher secondary education below 50 marks under the NCD.
So you see that you say that the private respondent is a better qualified teacher.
Not qualified at all for the primary teacher.
Right.
I'm the teacher. I'm not a qualified. My appointment is 1998. We are getting primary school.
Intimate, there is a representation. Intimate the.
No, madam, they have been given. Will lordships kindly have a look. Page 27.
Oh, intimation has been given.
Yes.
And that is under challenge.
That is under challenge.
Then in that case, let them file.
In the meantime, I tell you, lordships, twofold submission I'm making. One, if your lordship decide the issue, your lordships can injunct them not to accord approval to the appointment of the teacher in charge, or your lordship, or your lordships, my lord.
Higher secondary. She has not passed higher secondary.
But what he is saying, I'm the teacher. I'm not higher secondary pass. No. This approval. Yes. The book has been filed. Now the appeal is pending before the let him submit. Let him finish. Let him finish. I will.
Let me see. Paragraph 3, you do not possess the training qualification. Paragraph 5, you have written fair. When did you get the appointment?
In 1998, I got the appointment. In 2015, approval was there. In why from not 1998, an appeal was taken out. That is pending. Approval, your lordships kindly have a look, page 19 by the DI of schools, page 19.
You please show me your educational qualifications.
Yes, my lord, I have annexed that. Page 21, University of the Calcutta. And my lord, as I was appointed in 1998, 1992 training qualifications that has been given, and that I have annexed. And page 21 is the University of Calcutta.
Please come. The petitioner claims to be the senior most approved assistant teacher of a primary school. Stop. She is aggrieved as her case has been ignored for appointment of teacher in charge, and the junior most teacher has been appointed as the teacher in charge of the school. Stop. Challenging the same, the petitioner made a representation before the headmaster of the school, and the same has been replied by the secretary of the school by mentioning that the petitioner is not eligible for being appointed as the teacher in charge of the school. Stop. According to the school, the private respondent who has been appointed as the teacher in charge is a better qualified teacher and best eligible candidate to be appointed as the teacher in charge of the school. Stop. The approval of the private respondent as teacher in charge, however, has not yet been granted by the district inspector of schools within bracket primary education. Stop. Paragraph. The private respondent is not represented today. Stop. The a district inspector of schools, director primary education Kolkata, is directed to revert with written instruction considering the documents annexed to the writ petition. Stop. Release the matter for further consideration on yes.
District inspector of school.
Approval you will give.
We have not given approval. I don't know. I have no instruction.
That is what he is saying, that you have not given approval. Prior to approval, you have to look into these papers. Look into it. Come back 20th of July 20. Stop. In the event approval is granted prior to the adjourned date, the approval shall abide by the result of the writ petition. Stop. Let further notice be served upon the non-appearing respondent and affidavit of service be filed on the next date. আজকেরটা রেখে দেবেন। Regular bench.
If the approval is not being granted, it is submitted by all. Your losses kindly.
I have recorded that approval has not been granted. It's an averment.
There will be no further scope before the other bench because already your lordship passed an order.
What scope?
Because of the your lordship is not passing interim order, only 7 except abide by.
Yes.
So my lord, your lordship don't pass this order.
Why?
Because my lord, I will not be pursue that judge to pass a further order.
Why? What is the requirement of passing a further order?
Because my lord, unless the approval is given, he will not be able to work as a teacher in charge.
Yes.
That's why my lordship can
As such, my
till
lord,
date
pass the order.
or status or
আচ্ছা আরেকটা জিনিস করে দিন তো, liberty to mention.
Liberty to mention.
In case occasion arises for early hearing of the writ petition.
That will be administrative problem. If the TIC is not.
Your lordship directed to file a report.
I have not directed to file a report. Let them come back with instruction as regards approval. What can I can do? I can prepone it. Instead of 20th. How long will it take to approve? 2 weeks?
Calcutta district.
2 weeks? তাহলে 6th of July করে দিন। 6th of July.
Item number 13. 13, my lord, I appear for the petition.
Yes.
But after mentioning before, my lord, I have effected fresh service upon the state, my lord. This is my affidavit of service. But the petitioner has been selected for the post of the sub-inspector in food and Department of Food Supply, my lord, Government of West Bengal, my lord. But his appointment is withheld since, my lord, a criminal case is pending against the petitioner, my lord. But the criminal case was initiated in 2015, my lord, over my lord, the dispute between two groups, my lord, riotary. My lord, thereafter, my lord, the charge sheet was submitted under section, my lord, charge sheet page 23, my lord, kindly see, my lord, under section 147, 148, 149, 323, 353, 34 IPC, my lord. All are, my lord, the punishable with imprisonment less than 7 years, my lord. And petitioner along with other 39, my lord, the co-accused, my lord, have been charge sheeted, my lord. My lord, our grievance is, my lord, since the but the crime against the petitioner is trivial in nature, my lord, my appointment may be considered in terms of the judgment passed by the Honorable Supreme Court in Avtar Singh versus the Union of India, my lord, which I have indicated before the Honorable Coordinate Bench also, my lord.
Yes, the judgment is here.
Yes, my lord. Paragraph 38, my lord.
Yes.
But here, my lord, the important paragraph for me is, my lord, the 38.6, my lord. But in case when fact has been truthfully declared in character verification from regarding pendency of a criminal case of trivial nature, employee in facts and circumstances of the case in its discretion may appoint the candidate subject to decision of the such case. But there is direction of the Honorable Coordinate Bench to file a report. No report has been filed. But my prayer is, my lord, let the authority consider my appointment in terms of the judgment of the Honorable Supreme Court, my lord, in this Avtar Singh, my lord.
Where is the report?
But no report has been filed, my lord.
Where is the report?
On behalf, I am appearing on behalf of Public Service Commission.
It is you who will
No,
give
my lord, state,
appointment.
my lord, the state, my lord.
Tell with the state because I am a recommending body. Lordship.
Did you recommend his name?
Yes, yes.
Oh, your name has been recommended.
Yes,
His name has been recommended, but due to the pendency of the criminal proceeding,
That I understand.
With the state government.
Secretary, Food and Supplies Department.
Fine.
Then taking instruction means again it goes. What can be done? Acha, please come. No report has been filed by the state respondent in terms of the order dated 24th February 2026 till date. Stop. The Secretary and Food and the Secretary, Food and Supplies Department is directed to take a call whether to appoint the petitioner as he has been recommended for appointment.
My page 14 is my recommendation, my lord. Serial number 18.
Serial number?
18, my lord.
Ashish Dash. Recommended for appointment
Post of Sub
in the
Inspector.
post of Sub-Inspector in the Subordinate Food and Supply Services, grade 3. Way back on 29th April 2024. Despite his involvement in a criminal case, which according to the petitioner, is trivial in nature, carrying punishment of less than 7 years. Stop. A decision shall be taken by the aforesaid respondent relying on paragraph number 38.6 of the judgment passed by the Honorable Supreme Court in the matter of Avtar Singh versus Union of India and others, reported in 2016 8 SCC 471. Stop. The appointment, if allowed, will however be subject to the decision passed in the pending criminal case. ঠিক আছে? Let the report be made ready and circulated by 6th July. Release the matter on 13th July. Affidavit of service is taken on record.
$14 million time for the petition. No, I got but but the 14 my lord, I am for the petitioner, but my claim seeking appointment on compassionate ground is pending before the authority, my lord. But I have submitted the documents, my lord, as per the instruction of the subdivisional land and land reforms officer. My lord, the page 28 is my last communication. The last communication 9 July 2025, my lord. Thereafter, I have submitted the document on page 29. My lord, the petitioner's father was a revenue inspector, my lord, attached to the office of the subdivisional land and land reforms officer, Shodor Howrah. My lord, the lastly posted at my lord BLRO office, my lord, Jagat Bollapur.
No decision has been taken. Let them take a decision.
But since on the last occasion, the learned advocate had submitted that the additional respondent is the competent authority, fourth respondent, but the fourth respondent may be directed to take a call.
Yes.
As such.
The petitioner's prayer seeking compassionate appointment is pending consideration at the end of the additional district magistrate and district land and land reforms officer, Howrah. Stop. It appears that the petitioner was directed that the petitioner is one of the dependent family member of late Oshim Narayan Ghoshal, who was serving as revenue inspector and who died in harness on 11th of March 2024. Stop. The petitioner claims to be the dependent. You are the married daughter. Dependent married daughter of the deceased. Stop. The petitioner was requested to submit documents seeking employment way back in July 2025, which the petitioner submitted immediately thereafter. Stop. There is no response from the end of the authority. Stop. As it appears that the additional district magistrate and district land and land reforms officer would be the competent authority to take a call in the matter, accordingly, the instant writ petition stands disposed of by directing the aforesaid respondent to take a decision on the petitioner's prayer strictly in accordance with the relevant rules at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If any document is wanting from the petitioner, the same shall be immediately intimated to her. Stop. The fate of the petitioner's application shall be made known within the time limit as specified herein above. Writ petition disposed.
At one opportunity of hearing, my lord.
See, they will make the necessary inquiries, 3-man committee, a lot of formalities there. What further opportunity? This includes an opportunity. Yes, please.
Oh, good. We are so glad to see her.
But I have a copy.
But
Copies
copies
there
are there in the
Sharthok.
server.
In Sharthok, from the Sharthok, you'll please download copies.
May I move?
May I submit a copy?
To whom?
The state.
It is up to you.
Because,
Was
Can
it
is
not served earlier?
No. Can
Yes.
is not there in the server.
It's not in the server.
Can was served.
Earlier learned that. Directly to the
All right, sir. And what is Can 1 for?
Number Can 1 is supporting us. Can 2 is saying that no.
Opposing.
Opposing us.
All right. Yes.
Well, a writ petition, my lord, is covered by your lordship's order. But my lord, I think my lord,
She will take time.
But my lord, kindly, my lord, this is my point. I'll just indicate in short, my lord.
There was a report directed to be filed.
Yes, report has been filed. I will give a copy of the report to her also.
stating whether certificates issued beyond the prescribed period have been accepted by the authority or
Yes.
not, and if accepted, why the same were accepted.
My
The
lord,
reasons for acceptance is given.
My lord, the
Has the report been filed?
yes, it has been served upon us. My lord,
But
the
it has not been
learned, my lord,
filed.
legal my lord, representative of the board was there, my lord, of the police recruitment board, my lord.
Because I don't think it has been filed in court.
It might not have been filed. I have the copy of the same. If
Of the
she's there,
board.
my lord, it's
All right, she'll take instruction and come back and please file the report because copy has been served upon the petitioner. That means the
my
report
lord,
is ready.
only point, my lord, is that
All right.
my lord, only point is that there are other matters also in the list, my lord. One of the matters of Mr. Shamim is also there, where the police recruitment board is the, my lord,
Answering respondents.
answering
and taking
respondents in
steps.
other matters. The recruitment is complete, and my lord, Lordship may remember in one of my
Appointment
matters,
letters have not been issued.
only for the model code of conduct.
No, that is long gone.
Now, my lord, as of today, it has not been issued.
Yes.
Now, my lord, if they issue, then abide by the result, that is there. No, my lord, my humble submission, if these appointment letters are issued, then we will be in prejudice. So therefore, kindly keeps this matter in this week itself. My lord, everything is there. We can satisfy your lordship. But my lord, since she is, my lord, appearing for the
Yes.
first time, I am accommodating her for
Please
the, my lord,
take
once.
the help of a senior counsel because this matter will have far-reaching consequences. And livelihood of several unemployed youths are involved. So please do take help of somebody senior who is acquainted in handling these type of service matters. All right.
My lord, my lord, kindly, my lord, she is there also. My lord, the instructing, my lord, West Bengal Legal Services, my lord, personnel who is there in respect of the police recruitment board, she is very well equipped. She has been
No, but then
assisting.
the council will be making
Yes, my lord.
submission.
But she should also, my lord, because I think she is not having the whereabouts of her. I think she will contact her. But
You
my lord,
will get in touch, newly empaneled, give her this
yes,
breathing
one day
time.
I'm accommodated. I'm not. That is why it is from my end. But my lord, kindly keeps it this week on Thursday. There are other two matters also there.
It's impossible.
Well, both the parties are
Impossible.
both the applications are pending, my lord. Let it be there, my lord. Lordship.
I'll hear you. I'll
Should be
hear
at the
you.
time of hearing.
Report will also circulate to us.
That I'll give. I'll give. That I'll give.
He doesn't have a report. How can
I will give. I will give.
He can always send something.
I make it not this week? Come back next Monday. You get the weekend. Get yourself prepared. Next Monday, the matter will remain in the list.
My lord,
Alright?
would your lordship be pleased, my lord? I had mentioned two other matters of the same.
Give the
recruitment.
number.
My lord, these I have mentioned.
Give the number. It will appear.
Yes, my lord.
Take
Item numbers,
the
my lord.
report as directed to be filed. Video order dated
275,
2026 has not been filed till date. Though it has been submitted by the learned advocate representing the petitioner, that copy of the same has been circulated. Stop. There has been change in the panel of the state councils. Stop. The learned advocate currently representing the state doesn't have the papers. Stop. Learned advocate for the petitioner presses for hearing of the writ petition for consideration. Don't write hearing. Consideration. Stop. To allow the learned advocate representing the state respondents to come prepared, release the same on 22nd, next Monday.
And my lord, they will be not insisting upon the hard copies of the petitioner. One liner would help. Because we are going there.
Is anybody insisting?
Yes.
Who is insisting?
Everyone is insisting. Everyone. Even from the desk of the government advocate, they are not receiving our notices in spite of there being an order when it is being shown.
Let soft copy of all documents be handed over, be circulated to the learned advocate representing the respondents.
Yes. And affidavit of service of the
Taken
same
on record.
at the first.
By having received.
Yes. And my lord, let the matter, my lord, since it is concerning the police recruitment, let this matter appear at along with 275, 276 of the my lord monthly list, which I have already mentioned.
Give the numbers, it will appear together. Do not worry.
Yes.
Number gulo niye neben to.
No, 22 is Firdos's matter, I think. That is also same police recruitment.
Yes, that's why I'm asking.
Yes. Oh, so you are for the
Yes.
police recruitment board. Good.
Issue may be the different.
Issues are different.
Lordship, I'm for all the respondents along with Mr. Ramchandra Agrawal in this matter.
My lord, this matter, my lord, my lord, your lordship had already taken up this matter earlier occasion directed to why this people are not been given the recommendation as well as the appointment letter. My lord, now the position is the division bench are already dismissed. Dismiss means, my lord, without interfering the order passed by the learned single bench. My lord,
Whose appeal was it? Whose appeal? Union of India's appeal? All right.
Union of
And what is the order passed by the learned trial judge?
My lord, coordinate bench was pleased to direct the respondent authority to consider the petitioner as my lord, rounding off 169.5 should be rounding off of 170 and allow the
Similar order?
Similar order.
So give me the number.
I don't remember the number. Similarly, my lord, considering the Atul Verma case, my
Uh-huh.
passed an order, my lord.
Yes, even I remember.
Height only, same.
Height.
24 selection process. Either 25.
See, it will be the same.
25.
Even if it is 24 or 25, if the issue remains the same, it give the number of the case.
I don't remember exactly.
Find it out. Your learned friend appears in all matters. He will be able.
Well, that's why I am saying that with regard to the I have the 2024 selection.
It will be the same.
My lord, that is your lordship directed to dispose of the matter. My lord, what I am submitting so to sanction of the my learned friend and as well as the my lord, keep it this matter pending and direct the respondent authority to recommend it and issue the appointment letter. Otherwise, they will
What
not
is your
confirm
height? What was your height?
Yes, my name has been incorporated. Oh, height has already rounding off. Medical has been done. I have been. My roll number has been putting in the withheld list.
Only because of this
Only
rounding
because
off?
of the they are.
Where is? Please show me. Please show me.
That is relevant page is my lord. Page 25 of my writ application. This is the relevant page of the withheld list. It's appearing 1381 serial number.
Shanajit Mondal, 1381.
1381.
If rounding off was the reason for withholding, and if this if this
that
has been
clear.
Adjudicated by the court, then he should get an appointment letter.
Much obliged, your lordship. Kindly keep
When?
this matter.
My lord, he is not aware of, my lord, your lordship passed an order. I don't remember exactly the writ number, my lord, from 2753 2874 and there on 3108, like this.
All right, then what has happened?
That your lordship was pleased to pass an order
For issuance
only.
Issuance of appointment letter.
Considering Atul Verma case, my lord.
All right, likhun to ekটুখানি. It has been brought to the notice of the court that the appeal which was preferred by the Union of India challenging the order passed by the learned.
My submission will be, my lord, on behalf of my client, my lord, that we have preferred an
SLP.
No. SLP has been done. Thereafter, my lord, we are preparing review, my lord.
The SLP has been dismissed. Three counter SLP has been allowed.
My lord,
This is
cost,
not the case.
with
One
cost.
SLP. Yes, it will be. It will be dismissed. Explanatory cost.
All right, I've followed.
I cannot say anything.
You have to say. Why I tell you? Because it is your client who comes to you for opinion, whether to file a review or not. You should stop them there.
My lord.
Otherwise,
I'm small for nothing.
Their appeal dismissed, our appeal allowed.
Yes. It
কি
was allowed.
বললাম প্রদীপ?
Where is the scope for review?
Wait. কি বললাম?
বলতে হবে না কি?
My lord, what I am.
Please wait.
You will kindly keep this matter pending.
I'll keep it pending.
Yes. Otherwise,
Learned trial court. In line with the principle of rounding off, as regards the height of a candidate seeking appointment in CAPF, comma,
My lord, may I
the
hand over the
petitioner,
piece of the order.
the petitioner's case. না আর কি বললাম শুরুটা কি দিয়ে করেছিলাম না না সেন্টেন্সটা কি দিয়ে শুরু করে brought to the notice of the court যে ওইটা has been appeal has been dismissed stop paragraph on dismissal of the appeal, comma, the principle of rounding off has been acknowledged by the honorable division bench. Stop paragraph. The petitioner's name has been incorporated in the list of withheld candidates only because he was given the benefit of rounding off of height. Stop paragraph. As the issue has been set at rest by the honorable division bench of this court in the matter of
My lord, that is the honorable Supreme Court's order, and this is, my lord, the appeal has not been dismissed. It has been disposed of without interfering the order of.
a dismissal has been disposed of without interference.
It is in another matter, although it's Alan
আচ্ছা in the matter of এই যে MAT such and such on 10th of June 2026 accordingly the only option right now left before the authority is to recommend for issuance of appointment letter in favor of the petitioner. Stop paragraph. Hearing of the writ petition stands adjourned till 13th July 2026. Stop. The appointment letter shall be made ready and issued prior to the adjourned date.
My lord, may I get back this order, my lord?
আচ্ছা একটা এই দুটো ফেরত দিয়ে দিন একটা সাবমিশন লিখে দিন তো learned advocate representing the Union of India submits that an application for review against the order dated 10th June 2026 passed in Debashish Ghosh within brackets Supra is pending consideration before the honorable division bench.
My lord, Atul Verma.
Oh,
Atul Verma.
this Atul Verma I am not considering. I am relying upon this. Ota bad din. Atul Verma before the Supreme Court go and
My lord, 17, 18, 19, 20 and 20.
Also, I am there with Mr. Verma, Mr. Agarwal.
17, 18, 19, 20 all.
16 and 17 I am there.
16, 17 record appearance. 18 were there.
Your Lordship, I am also there virtually for
Which
16,
appeal?
for 16, 17.
Individual appeal is pending without taking any
Appeal against which order? আচ্ছা 1 minute 18 এর ফাইলটা দেখি একটু 18 বিজয় কুমার রয় এটা হয়ে গেল তো পাপ্পু পাল হয়ে গেছে সেম অর্ডার 16
January 2026.
Yes.
Page.
And MAT number is 1551 2020.
But the issue has been decided.
And in that matter, they have not even filed the application.
That has been pending while my submission.
All right.
Learned register.
ওনার সাবমিশনটা রেকর্ড করে নিন তো
Opportunity to file
an
the
appeal
application.
from the order dated 8th January 2026 passed in the writ petition filed by the petitioner being WPA 28130 of 2025 is pending consideration. Take down one submission. As the issue in question has been set at rest by the Honorable Division Bench in the matter of Debashish Ghosh within brackets Supra, accordingly, the same principle ought to be followed by the respondent authority. আচ্ছা বলুন।
Appeal is MAT 551 of 2026.
MAT 551 of 2026. 26?
Yes, 2026.
All right. হ্যাঁ দাঁড়ান 18 19টা দিন 19
528 of 2026. Only changes is there.
528 of 26. And where is the single benches order?
Single
8th January 2026 single benches order. WPA 28106 of 2026, page 24.
Yes.
Matt.
Juboraj, my lord, FMA, my lord, number has been renumbered. FMA 472 of 2026. FMA 472 of 2020. Within time.
And single benches order?
Single benches order is, my lord, page 18.
No, page 18 is.
No, my lord. Sorry, my lord. Page 24. 8 January 2026.
All right. Page 24, single benches order.
Oblige your lordship. Grateful to lordship.
Yes.
Lordship, I'm for the petitioner, Lordship.
I have already submitted
Instruction by the commandant.
I find a
reply.
Medically unfit on account of defective distance vision, overweight.
Our fault, my lord.
Neither the patient appeared before the DME to receive result of the not give his consent from.
That's why the name has been appear in the written. Our part, my lord, but we actually
Unfit.
at the DME.
Yes, please.
Lordship, the scorecard says I am fit and qualified. My
No,
name,
your DME says you are unfit.
no, Lordship, I'll just come up with this, Lordship. No, Lordship, if Lordship sees the scorecard, it says that I am fit and qualified. My name appears in the merit list. Post filing of this writ petition, I received a reply. Everything is in the record, Lordship. I'll come to this, Lordship. Post filing of this writ petition, I got a reply of the representation wherein the authorities have reconfirmed that I have been finally selected. Now, in the instructions, they are coming up with a plea that by mistake my name is appearing as unfit. Now, Lordship, I'll come to the most important aspect, Lordship. Lordship will kindly, I am relying on their own documents. Lordship will kindly see the instructions which they have given on 22nd of April. Lordship will kindly see the second paragraph. 1, 2, 3, sixth line, last sixth line. Detailed medical examination report was conveyed to the petitioner on the same day and his signature taken as record in detailed medical examination report. Thereafter, neither the petitioner appeared before the DME board to receive the result of medical examination, that is memorandum of unfit annexure 1, nor give his consent for undergoing review medical examination. A copy of detailed medical examination report dated so and so, copy of medical and memorandum unfit are attached herewith as annexure R1, R2 and R3. So according to their report, annexure R3 is memorandum unfit. Now, Lordship, I come to annexure R3. Lordship will kindly take the third page. Annexure R3, third page, which they are saying it is the memorandum of unfit. Annexure R3, third page. Lordship will kindly see detailed medical examination status fit, remarks fit, DME final status qualified.
This is the error. This is exactly the error that has cropped up.
Whether this error can be, Lordship, is it accepted lawfully, Lordship? My scorecard says I am fit and qualified. My
It
name
is relying upon this. But you see, did you get R1? R1, the DME is there.
He signed the DME report.
On 2 counts. Please come. The exception filed by the petitioner to the
Lordship, then
report filed by the
Lordship, a re-medical
authority is
Lordship, a re-medical
taken on record.
Lordship.
Stop. The
Lordship,
petitioner participated in the recruitment process for engagement as constable within bracket GD in CAPF. Stop. His name featured in the list of where your name came?
Merit list.
His name featured in the merit list.
Yes,
Stop. The scorecard of the petitioner mentioned that he was found fit in the detailed medical examination. Stop. Thereafter, his name was enlisted in the list of withheld candidates.
No, Lordship, in the merit list, Lordship, they have themselves, they have. Withheld list is a separate list. Lordship will kindly see page.
Withheld rank. That page 12, my lord.
In the withheld list.
Lordship will kindly see their report, paragraph 3.
No, page 12, what is it? It is the candidates recommended for appointment.
Yes, yes, Lordship. Yes. Withheld list is a completely separate list, Lordship. This is the
Where is the
merit
withheld
list.
rank? Withheld rank.
Lordship will kindly
Oh,
see
ki bola?
paragraph 3, Lordship, of the report, Lordship. There he has stated.
List of candidates recommended for appointment with withheld rank. ঠিক আছে? On a perusal of the report filed by the authority, it appears that the petitioner was found medically unfit in the detailed medical examination on 2 counts. Number 1, defective distant vision 6/12 in both eyes and overweight. Comma the BMI 25.50. Weight is 79 kgs. Stop. As per the procedure, comma, DME report is conveyed. Now, was conveyed to the petitioner on the date of the examination and his signature was recorded. Stop. The petitioner never appeared before the board to receive the result of the medical examination. That is the memorandum of unfit. Neither gave his consent for undergoing review medical examination. Stop. Paragraph D. The result of the petitioner was erroneously fed as fit in the web utility form as well as in the proceedings by the recruitment board. Stop. Due to this error, the name of the petitioner was published in the merit list by the recruiting authority. Stop. After the unfit certificate of the petitioner came to the notice of the authority, comma, the same was intimated to him. Stop. Learned advocate for the petitioner submits that there was no error on the part of the petitioner, and it has to be taken that the fit certificate issued by the authority was correctly issued. Stop paragraph. Such submission of the petitioner cannot be accepted. Stop. It has been pointed out by the authority that the result of the detailed medical examination was erroneously fed in the web utility form. Stop. The report of the detailed medical examination has been handed over to the petitioner as well as placed before the court. Stop. It appears therefrom that the it has been clearly mentioned that the petitioner.
Lordship, may I just interrupt one point, Lordship? Just one point, Lordship. Lordship, even after filing of this writ petition, they have sent me the reply that I have been finally selected. Lordship will kindly see annexure P6 of supplementary affidavit, even after filing of this writ petition.
Acha, he is unfit on medical grounds. Stop. The court cannot permit a candidate declared medically unfit to be appointed in CAPF, which is a disciplined force and requires extra fitness for recruitment. Stop paragraph. The error which cropped up cannot be permitted to be perpetrated. Stop. The same has been rectified immediately on notice. Stop. The court permits such rectification. Stop. In view of the above, the candidature of the petitioner in the recruitment process cannot be permitted to be accepted. Stop. The writ petition fails and is hereby dismissed. He is not here. I do not see him. What can be done?
Lordship, may I just mention item number 34? Lordship, same matter, Lordship. I would like to withdraw the same, Lordship. Item number 34.
34?
Yes, Lordship.
You want to withdraw?
Yes, Lordship.
Let it be called on. Because I do not know who the other side is.
32. Sorry. I apologize. It is 32. 32.
It is better it goes on serially.
Okay, Lordship.
You are there?
Yes, same matter.
So it can be
not pressed, Lordship.
Learned Advocate 32, record an order, please. 32. Learned Advocate for the petitioner submits that her client does not intend to proceed with the writ petition any further. Stop. Next. In view of such submission, the writ petition stands dismissed as not pressed. All right?
Obliged, grateful, Lordship.
Huh?
Item number 22.
For your lordship order, the para 11 and 12, my lord, the authority of notification indicating that the matter is pending. That is,
This notice has been published. All right.
the state is there. Kindly take it up. It's like a next week.
Next Monday. This matter, I have told your junior in the morning, will have far-reaching consequences. A lot of unemployed youth, they have applied for recruitment. There are many candidates, right? And there are many issues also. Several writ petitions filed with different issues. A report has been filed in the matter which was taken up in the morning. Yes. Issues are different, right? No, there was no direction also. There was no direction. Since nobody was present on the last occasion, accordingly, direction could not be passed. You go through it first, make your preliminary submission. If you require a report to be made ready, please make ready and come back. I am simply adjourning and posting it next Monday. All right, to allow the learned advocate representing the state respondents to come prepared. Command release the matter for further consideration on 22nd. Stop. The notice published by the West Bengal Police Recruitment Board in the official website.